welcome to each and every one of you. Thank you for joining us this morning. My name is Roshan Ramcharita, and as the facilitator of the Public Law Specialist Clinic, it is my distinct pleasure to welcome and introduce to you our guest speaker today, Mr. Anand Ramlogan, Senior Counsel. Mr. Ramlogan should need no introduction to many of us, certainly those of us from Trinidad and Tobago, but he is one of this country's, and indeed one of the Caribbean's, leading attorneys practicing law for over 25 years now in civil, public law, and commercial litigation. He was called to the Bar of England and Wales in 1994 and is a member of the Honorable Society of the Middle Temple. He was called to the Bar of Trinidad and Tobago in 1996. He's also a member of the Bar of the British Virgin Islands and has practiced in many Caribbean jurisdictions. He was appointed Senior Counsel in 2011 and served as this country's Attorney General between 2010 and 2015. He is the holder of a Bachelor of Laws degree from the University of the West Indies, Cave Hill, and a Master's in Corporate and Commercial Law. He's the founder and head of Freedom Law Chambers based in San Fernando, which is now the leading public law chambers in the country. While he has practiced and appeared in many cases across the civil landscape, he is perhaps best known for his work in public law related cases, constitutional law, human rights cases, judicial review cases. He has appeared in many historic landmark cases that have helped to transform and develop the law. In fact, the jurisprudence, the public law jurisprudence landscape is perhaps littered with Mr. Ramlogan's name as lead counsel for perhaps in the past 15 to 20 years. As I said, he appears in our superior courts, including our highest court of appeal, the Privy Council, regularly. He has done over 60, and I'm sure Senior will correct me, it's probably much more than that, over 60 Privy Council appeals. He provides legal advice to a number of governments, law firms, public bodies, and NGOs, and is regularly retained to lead legal teams in complex disputes to vindicate the rights of aggrieved clients. He is without doubt one of our region's foremost and top legal minds. And just to mention a few of some recent cases that he would have appeared in at the Privy Council, Maraj and the Cabinet of Trinidad and Tobago, which challenged the government's decision to postpone local government elections, JM and the Attorney General, a 2022 case which concerned the rights of the child, Achille Charles and the Attorney General, which some of you should know as the right to the no bail for murder case. The Privy Council held that provision of our Bail Act was unconstitutional and that those persons charged with murder have the right to apply for bail. Most recently, perhaps week after week, you would hear decisions coming out from our local high courts that would have had the case, the claimants would have been represented by Mr. Ramlogan or his chambers. One of those recent decisions was the cremation case, or the open pyre cremation case, which involved a challenge to the ban on open pyre cremations during the COVID period and the public health regulations banning that for a certain period of time, and that was held to be unconstitutional. I can go on and on to speak about the number of cases Mr. Ramlogan has done and his bio, but I will stop here. Before I ask Mr. Ramlogan to begin, I just want to acknowledge the presence of our principal, Ms. Samaru, who is here, and of course other members of staff, and of course all of you students, including the members of the Public Law Clinic, for attending this morning. So I hand over now to Mr. Ramlogan.
Thank you very much, Ms. Samru, Principal of the Law School, Mr. Ramcharita, other distinguished lecturers and tutors at the law school, and you, the future attorneys. I know school is on a break, so I'm surprised to see so many of you here. It means that you are well prepared for your exams and didn't need to be elsewhere, or you saw this as part of the preparation. I'm a graduate of the University of the West Indies, firstly, and of course I'm also a graduate of Hewing Law School. And public law and constitutional law is the axis of the rule of law. It is the axis of the rule of law because when it comes to the protection of fundamental rights, that is rights that are owed by the state and rights that are enforceable as against the state, those rights are what we call the bedrock of constitutional law and public law. So the most significant change in the law has been in the field of public law in the last 10 to 15 years. And I'd like to start off by just tracing historically why that is so. I mean, you have done a bit of English law, and in the good old days, the church and the state were one. So when the church and the state was one and you had ecclesiastical law, the concept of a law that would bind the crown was something that was very nebulous. Because at the end of the day, the state and the crown would be something that has to reign supreme. And you trace it from there. If you trace it from there, you will see the ebb and flow throughout history is that you had a gradual seesaw. The seesaw was this. The crown and the king started dipping slowly, and the concept of something that would be a hold over the state started rising gently. That seesaw took place over centuries, but it emerged out of the fact that the too much power concentrated in the hand of any one man or woman is likely to be abused. And that was in fact the case, where you saw that happening throughout history, and the need to have some amorphous, invisible check and balance on the exercise of power that is liable to be abused by anyone started rising. So public law and constitutional law was the fulcrum beneath that seesaw that started to put in check and balance the exercise of power by the state. So much so that when we had the separation of the church and the state, which led to modern developments, we in the West Indies, in 1962 in Trinidad, we came up with our own written independence constitution. And that's significant because the constitution now is the fulcrum beneath that balance between state and the religious bodies, state and the judiciary, state and the executive. And that's what we know today as the separation of powers doctrine. I mean, in a stunning judgment delivered by the UK Supreme Court in the case of Miller, they actually adjudicated on the question of Parliament's ability to prorogue itself, something unheard of. I just finished an election petition appeal. And election petitions as a jurisdiction that was never, ever given to the courts. Parliament itself determined election petitions. Not many people know that. The courts had no jurisdiction and power to determine election petitions. That was a function Parliament itself would exercise because it jealously guarded its own membership. So it was only recently that they gave and ceded that jurisdiction to the courts. And that is how we were able to do election petitions. So today, the modern concept of separation of powers, it has in its root the concept of the rule of law, which for us is rooted in the Constitution. So today, that's the little background to big up public law so that you'll know to how important it is. Because there is no other field of law, no other branch of law. This is the apex of the legal pyramid. It is the mighty battle between David and Goliath. And you are, and the law is the slingshot and the pebble. You are the David, the state is the Goliath. Because you're coming up against the might and muscle and weight of the system. It is the George Floyd moment. It is all of the George Daniel moment from Trinidad, the Ravi Balgobin Mirage, all the busybodies, and that's what it is. But the law is made by average men and women who have a sincere desire to challenge the state. The late Reginald Dumas, one of our greatest icons and heroes from Tobago, former head of the public service, is one such man who challenged the state on a very simple issue about the composition of the Police Service Commission. And that has led to a groundbreaking revolutionary development in terms of public law, which we'll come to. So I'll take you through some slides that my assistant, Mr. Brian Carey, has prepared early this morning. So I'm not really a techie person, but I know what I want to say, but I hope that the slides, I can match them. But I'll start with the question of mala fides, because the most significant development, I think, in the law has been the removal of mala fides. And what is mala fides? Mala fides means bad faith. And the state had this concept that if you wanted to sue the state, you didn't just have to show that your rights were breached. You had to show that it was deliberately and intentionally breached. I discovered this as a young lawyer when I came back from England, because I found it strange that I was born and I grew up in a country where there were cries of discrimination from both sides of the ethnic divide. And yet still, we didn't have a single discrimination case for a natural living human being. And I couldn't understand that. The only two cases there were for major corporations. But how could there have been a society constructed socio-politically, such as ours, and you don't have a single discrimination case? In racially homogeneous societies, where you have one race, you had more discrimination cases than a country where you had a multiracial society. So I thought something had to be wrong. It's either we have no racial discrimination, or something is wrong with the law itself. So I started upon it, and I looked at it, and the first case that it emerged in was a case I did for a lady called Marlene Kudry, who was the then CEO of the San Fernando City Corporation. And what I learned is that the reason we couldn't have discrimination law in this country is because the status quo had said to prove discrimination, you needed to prove, one, that you were similarly circumstanced with the other person. Two, that despite being similarly circumstanced, you were treated differently. And that should be discrimination. I'm similarly circumstanced, but I've been treated differently. We both have 5 O-levels. We both apply for the same job. There are 2 vacancies. One person gets it and the other person doesn't. We are similarly circumstanced, but I've been treated differently. We both have 5 O-levels. That should be enough. But what strangled it was a requirement that in addition to proving those 2 things, you had to prove that the decision maker was actuated by malice, bad faith, and a hostile intention towards you. In other words, you had to prove not just that I had 5 O-levels just like that person, they get the work and I get it, and it have 2 vacancies. You didn't just have to prove that. You had to prove that the person who refused you the job and gave you the other person, that they had a hostile personal intention to discriminate against you in bad faith. And that requires you to climb into the mind of the decision maker, open it up to the court, and say, well, look, here it is. He was thinking that I did this because this person is left-handed, Indian, Chinese, African, whatever. Virtually impossible. And this was what the state of the law was, because the status quo in our post-colonial society was such that they said you had to have a presumption of regularity and integrity, meaning that you had to presume that people in public life acted in good faith, competently, and fairly. And that was the problem. Arising out of that, you had to prove bad faith on the part of the decision maker. So the first I don't know if anybody could read that. It's very small, Brian. But anyway, you will see it from the first case would have been Smith and Williams. And this is what the Court of Appeal said. Are you all able to read it? Oh, not really? No? Oh, you are? Okay. Right. And this is what the Court of Appeal said in 1980. They said, there is a presumption of regularity in acts and conduct of officials. Therefore, the burden of proof is on the aggrieved party to establish mala fides in the administration of the enactment. In my opinion, so long as it can be shown that the act was a hostile act or an intentional and irresponsible act, that is to say, an act done deliberately and without justification, that would be enough to rebut the presumption of regularity. Backward law. The presumption of regularity meant that the burden was on the aggrieved citizen who had to dislocate that presumption. You start off 2 steps back. The state has a presumption in its favor that it acted regularly, it acted fairly, and it acted validly. And you had to now disprove that. And you can only disprove it by proving the discrimination was intentional, irresponsible, deliberate, and hostile. How on earth can you prove that? You can have benign discrimination. That is what I argued. You can have unintentional discrimination. So, for example, suppose I said that, look, I think that, I think women should really, take care of the family, and they should go home to make sure that they have roti swelling and things for the husband when he reaches home from work with a nice meal, and therefore to support the institution of the family, which is failing in society, I will not allow women to work overtime in my law firm. Is that a hostile intention? No. Is that acting in bad faith? No. I actually have a very good intention to uphold the family values that are declining in society. Is it discriminatory? Obviously it is. The answer is yes. So it is just one example to illustrate the point. But you see, what I advocated is that you needed to have a results approach, a results-oriented approach to discrimination. And results-oriented meant that intention was irrelevant. And if intention was irrelevant, it didn't matter whether it was hostile intention, good intention, bad intention. It just didn't matter. The intention of the person and the state should not be relevant to the question of constitutional rights. What is relevant is whether the right has been breached, not the intention. So in the case of George Daniel and the Attorney General, George Daniel was a hero of mine. He was for the disabled rights community. And George Daniel couldn't access the High Court because we didn't have a ramp for people with wheelchair. I was rushing on my way to court, and I saw this guy in a wheelchair looking at the stairs. And I was rushing. I was late for court, and I just said, something wrong? He said, yeah, I have to go to court and I'm late. I said, well, what's the problem? He said, well, I said, shit, we don't have any wheelchair access. So I hold him now to pull him up. He nearly fall out twice. I yank him up the stairs, back up. And I top, I said, but listen, I never thought about this before. He said, Mr. Ramlogan, I don't know, boy. He said, don't think about disabled people here. We can't serve on the jury. We can't even go in a witness box with our wheelchairs. It's too small to accommodate us. It is as though they've amputated not just my foot, but they amputated me from society. Those were his exact words. I sued the state for discrimination. Was it intentional? No. Did they have a good motive or a bad motive? Who cares? But we sued the state, and in the landmark case of George Daniel, we established that that was discrimination against the disabled community. And today, when you go to the Hall of Justice on the left, you will see that they now have a lift. And they've actually constructed a ramp that people with wheelchair can access. And now we have people on wheelchair actually serving on juries and becoming full members of society to participate in the administration of justice. But if I had to prove a hostile intention, I couldn't have won that case. And that's the point. And that is why it was so important to jettison this requirement that you have to prove a hostile, deliberate intention. Because you can't really prove that. And that was the law until I started chipping. It took me 10 years of my career to chip away at this requirement. They repeated it in the case of Casey Confectionery. I won't read it because it's there. And then it was in the case of the Trinity Cross case. The Trinity Cross, for those of you who don't know, was the nation's highest award in Trinidad and Tobago. And a pundit was awarded the nation's highest award for his social work. And when his turn came to collect the award, he said he had to politely decline because as a pundit and a Hindu priest, he said he didn't think it would be right for him to wear the cross any more than it would be if the national award was an Om or a crescent and a moon, and it was to be pinned on the archbishop or anyone else. And he politely declined. He said he was happy for the recognition and the honor, but he felt that symbolically it's not something that he could countenance. So I found that very strange. I hadn't thought about it before. So he came to see me together with a member of the Muslim community, and I had a thought about it. The biggest argument against you is, well, where's the discrimination? Nobody's forcing him to take the damn award. You say, no, there's no discrimination. It's not a law. Discrimination arises out of a law. You know? So I thought about it, and I said, I could understand the point. And there are two things I learned in that case. The first is, as students and lawyers, before you answer questions, what you're taught to do here from LLB days come up is to answer questions. What I want to try and get you to do is not to answer questions, but before you embark on the intellectual journey to answer a question, question the question. Because if you ask the wrong question, you will get the wrong answer. So that my whole career is built on questioning questions and not responding to questions. I start by questioning questions because hidden in a question is always an assumption. So the question is not whether the Trinity Cross was discriminatory. That wasn't the question. The question is, why did we have the Trinity Cross as the nation's highest award? I have to answer that first before I can then go to the second stage. So I questioned the question, came up with answers that rendered irrelevant the second stage, and I launched the case. We lost in both courts, and in the Privy Council, they who imposed the Trinity Cross, in a landmark judgment, held that it amounted to indirect religious discrimination under our Constitution. And that is when we abolished the national award, and caused today what we have, the Order of the Republic of Trinidad and Tobago, which is a more neutral award and can't cause offense to anyone based on their religious belief. So the question is, it has historical origins, yes, La Trinity, and the story of Columbus and the sighting of the three peaks, and that's where Trinity Cross comes from. But it also came from Great Britain. It came from there because they still have the Victoria Cross as a national award there. But it came from there. But we were forging, when Dr. Eric Williams spoke those immortal words about forging a nation, forged from the love of liberty. When we speak about equality, and we are forging a nation comprising indentured laborers, freed slaves, and in the post-colonial era, we are taking a jigsaw puzzle, a social jigsaw puzzle, but crazy glue and trying to make it work. That crazy glue is the law. The crazy glue is the law that holds the society together. So, it was based on that we were able to challenge that and establish in that case again that intention. Christopher Columbus and the Queen and everybody didn't have intention to discriminate against no Indian and Hindu pundit and so on. They probably didn't even know them exist. But the result was that it was discriminatory. And that is how the case was won. But if that had remained the law, the hostile intention, I couldn't have won that case. So the important point is, the first thing is, intention to violate a fundamental human right, I think is the most significant thing that is no longer the case. You don't need to prove an intention. What you need to prove is a results-oriented approach. Has the right been violated? And if it has, well, the intention of the state should be irrelevant. And that goes for all fundamental rights now. And that is as a result of the Privy Council in Mohanlal Bagwandin, when I took this case, I knew it was a weak case, we lost it, but I got what I wanted out of it, and that was this statement by the Privy Council. They said the lordships are inclined to the view that there may have been a degree of confusion between two distinct concepts, the presumption of regularity and the necessity for proof of deliberate intention to discriminate in a claim for inequality of treatment. And basically, you'll see lower down, they said this is not required in discrimination cases in the United Kingdom, James and Eastleigh Borough Council, where the majority preferred what Lord Lowry said, which is, he termed it the causative to the subjective construction, and held that discrimination could be established even though the respondent counsel had not intended to discriminate between men and women. So subjective is irrelevant. That's the intention. Causative is the results-oriented approach. Did it cause discrimination? Did it cause you to lose your liberty? So when police arrest someone, the police often come to court and matter say, well, we never told him he's under arrest. Well, that's true. But if your action and conduct is such that the man was not free to leave and was deprived of his liberty, the fact that he's not free to leave means that your intention is irrelevant. He has been deprived of his liberty because he can't do what he wants. If he wants a meal of food in the station, he can't go outside and buy, KFC. He can't. So therefore, you could say, I never intended to arrest him and charge him. I never intended to deprive him of his liberty, but that's irrelevant. That's why it was so important to get this out of the way, and it has revolutionized and opened up the law as it was in relation to fundamental rights, because you no longer need to prove intention. So that's the first big ticket, I would say, the first big ticket development in public law, that the state can no longer shield behind the presumption of regularity, the presumption of integrity on the part of public officials, and that you need to prove, because of those two things, you need to prove that they actually was mean and wanted to discriminate against you, or they wanted to take away your liberty. You don't need to prove those things anymore. It's whether the question is whether it factually resulted and produced a state of affairs that is violative of your right. Now, I could take questions at the end or in between. Feel free, it's fine. The second, and just to show you that that's the law now, we go to slide 6, just to jump ahead, and you'll see after all of that, in between that was the radio license case with the Mahasabha and so on. Anissa Webster in 2015, Lady Hale declared that the law is now, you'll see at part 5.5 in the Privy Council judgment, it is not necessary to prove mala fides on the part of a public authority, unless, of course, it's specifically alleged. So that is no longer the law, and it took 10 years to get that. So the point is, for the better part of almost 30 years, the constitutional right to equality of treatment meant nothing because of that judgment from the Court of Appeal in Trinidad and Tobago that said you needed to prove a hostile and deliberate intention to discriminate. And and as a result of that, we have dynamited the logjam that existed. So I take you next to the next big ticket development. The next big ticket development in the field of public law is the concept of proportionality. We have been struggling for years as to how does one measure the vires and the lawfulness of state action? And the answer came very late on in the case of Surat, where Lady Hale has done some remarkable work. She's now retired, but she did some pioneering judicial work that has really impacted on the development of the law. And this was it was an interesting case because this was the state was challenging the constitutionality of its own legislation. It's a very rare thing because Mr. Surat wanted to activate the Equal Opportunities Tribunal, and the state had not put it in place even though the act had been passed. And when he sued, the state said, well, the act is unconstitutional. So the state was saying its own act was unconstitutional. And this is what Lady Hale said in the majority judgment. She said, these are both qualified rights which may be limited by either general legislation or in a particular case, provided the limitation pursues a legitimate aim and is proportionate to it. Provided the legislation pursues a legitimate aim and is proportionate to it. Now, what does that mean really? It means that if you want to challenge, so if you come by me with a case and you're complaining about something done under the law, and you will have clients who will come to you to do this. Before you embark on saying, well, you know, was this done in accordance with the law? What I do is I don't answer the question. I question the question. So what do I mean by that? I'm doing a case right now, still in the early stages, but a woman got pregnant twice in 24 months. And they paid her maternity benefit twice. But they came back now and demanded that she refunds the second one, because there's a provision in our Maternity Act that you can only get one maternity benefit within 24 months. You can get it more than you can get more than one, provided you don't get pregnant more than once within 24 months. Now, the note that I received from the lawyers that briefed me in the matter was all about, you know, that situation about 24 months and whether she's within 24 months and so on. But I take a different approach. Is the law itself valid? And I don't think it is. So I'm about to challenge the Maternity Act on the basis that the state has no business in telling you, you know, when you should have children to be able to get that, to be able to get that. So I mean, it's going to be a landmark and an interesting case, because you know there is comparative legislation elsewhere, so it will impact on a lot of countries. But the point is, you question the law itself, but that's where proportionality comes in. That's the test. The first question is what's the aim that Parliament had in mind? What's the objective? So that's the first question. And you have to, most of the times they would have a good objective, a legitimate objective. So that's the first hurdle you clear. And the second one, if you answer that, is, well, is the objective sufficiently important to justify the interference with a fundamental right? So that's the second test. So if Parliament had a legitimate aim, that's fine. You then go, well, was that legitimate aim so important that it justifies the interference with the fundamental right? And then, if the answer to that is yes, you go to the third test, which is, well, okay, but could a less intrusive measure have been adopted that would have achieved the same aim without being so invasive and violative of the fundamental right? Was there a less intrusive option? That's the third step. And the fourth step is having regard to the severity of the impact on the fundamental right. Having regard to the severity of the impact on the fundamental right, could we say that Parliament struck a fair balance between the rights of the individual on the one hand and the rights of the public and the wider society on the other? And you go, if at any one of those steps, and the answer is in the negative, you have a good case. So let's take this, for example, by reference to, the Achille Charles case, for example. For over 100 years in this country, murder was a non-bailable offense. So a man charged for murder could not get bail. Now, this was particularly egregious because murder can occur in a wide variety of circumstances, and you're presumed to be innocent. A guy came to see me who I grew up with in my village. We actually went to primary school together. And his story was that some of the guys hired him in the night because they said their aunt was ill and they wanted to go and visit her. These are guys we all grew up with, playing football, knowing and so on. And he said, okay, fine. His daughter was ill, and he didn't have money to take her to the doctor the next day. So he accepted the PJ to carry them. He knew the guys. He took them there. En route, they stopped by the pharmacy. Said they want to buy some tablet for the old lady and thing. They went. He pulled up outside. They went inside. An hour and a half later, they came back. That thing wrapped up in foil. They said she baked and thing. They offered him some cake. They offered him the thing. He eat a piece of cake, and they laughed and they went on the road. They gave him his $250 for the PJ, and that was that. 3 days later, police came and arrested him. Those guys went to put on a robbery, and they actually murdered her during the course of the robbery because the lady fought back. Now, this poor guy is completely innocent, but he's charged with murder, and he can't get bail. And in our system, the minimum wait is over 10 years for a murder trial. So he would lose 10 years of his life in prison, being presumed innocent, which means nothing. 10 years is the pre-trial delay, and the man is inside there waiting for a day in court to establish his innocence. And because we don't have categorization of murder, he's charged with murder, and there's only one charge, murder. Not murder in the first degree, second degree, third degree like in the US. It's just murder we have. And of course, you have people like crimes of passion, for example, man working whole day mixing concrete and then going home in the evening and, working PJ, pay down a little higher purchase for the mattress and the bed, and come home and find the next man on the mattress with the wife, and crime of passion. Lick him up. Well, that might be a bad word, but okay. In the circumstances. But the point is, is that man a threat to society such that he should not get bail? It's a crime of passion. I find my fellow shaking their head too readily in this one. But the point is, it's a crime of passion, and bail is meant to be denied because you need to protect society from the risk and the threat that this person poses to others. So for 100 years, you couldn't get bail, and this law stood the test of time. But because of that incident with that guy, I said, let me take this on. The case went all the way to the Privy Council. Chief Justice Ivor Archie wrote a brilliant, illuminating, and erudite judgment in the Court of Appeal, saying that, it's unconstitutional, it wasn't a safe law, and the Privy Council upheld it. Why is that so? Why is that so? The grant of bail is a judicial function. When Parliament passes a law that says murder is non-bailable, who is denying you bail? It's the Parliament. When Parliament passes a law denying you bail on the basis of the nature of the offense, it is not a judicial officer that is denying you bail. It is Parliament denying you bail. But I argued it even further. It was not Parliament that was denying you bail. You know the danger in it was? That's all right. The person that was denying you bail would have been the police officer. Because the police officer is the one who will take the file to the DPP and they will lay a charge of murder. From the time you're charged with murder, from the time your charge is laid, you have no right to liberty. So that's the danger in it. From the time you are arrested and the charge is laid, you lose your liberty. And you can't even go to a judge. There's no opportunity for bail, nothing of the sort. So I said it was a breach of separation of powers because only the judiciary, the judicial arm of the state, should have the right to deny you bail or to listen to your application for bail. We long gone past from the days of the king, where the king could pass a decree and say, thou shalt not be freed. 200 years later, we're in a state where Parliament, representing the state, tracing back to the crown, was going to say, well, no bail for you. And regardless of the merits of the case. And as a result of that, you have hundreds of people, many of whom are innocent, in prison. And I remember if you look, the live stream of the recording is on the Privy Council website. You will see one law lord was telling me that he didn't agree with me that the presumption of innocence arises. And I thought something had to be wrong with him. I tell him so in the Queen's English, I said, but how artificial would that be? That you're telling a man don't worry, you're presumed to be innocent, but 10 years a life loss, your wife on the outside looking for, an alternative income partner, bank, mortgage, you can't pay a mortgage, bank take it. I mean, your life is destroyed. What nonsense you're talking about that you have a presumption, a right to be presumed innocent. The presumption is meaningless. It means absolutely nothing. So now, after 100 years, Achille Charles has established that you can apply, you have the right to apply for bail. And we have had quite a few persons who the judge must assess. Not that you have a right to bail, you don't have a right to bail. You have a right to apply for bail. The judge has to determine that you do not pose a risk or threat to society and then grant you bail. So that's where the judicial discretion comes in, and you have to make sure that you know it. But again, was it pursuing a legitimate aim? Yes, perhaps. They wanted to keep society safe by having people who are accused of murder inside. Was the means employed rationally connected? Perhaps. Perhaps, because no bail. One can see no bail means you wouldn't get out so that you're protecting society. So the aim is to protect society. I say no bail if you're charged for murder is rationally connected. Put in the case exercised. Could a less intrusive measure have been used? Absolutely. Absolutely. That is, let the judiciary determine the application for bail so that they could only grant bail so that people who genuinely deserve bail and do not pose a threat could get it. Did it, having regard to the severity of the consequences, did it strike the right balance between your individual rights and the rights of the public? The answer is no. The answer is no. So, I mean, however, it was simply not proportionate either. It would not have been proportionate. So that's the next big step. The big development in public law was the concept of proportionality. The next one I take you to is the developments in the right to protection of the law. A right which does not mean what it says. Protection of the law as a fundamental right does not mean that you have the protection of the law in a literal sense, and if the law is, somehow the law is breached in relation to you, that your right to protection of the law is infringed. That's not what it means at all. It started off in Errol McLeod and the Attorney General. They said access, that is at the bottom here, And the Privy Council said in McLeod and the Attorney General that access to a court of justice for that purpose, meaning bringing your case, was protection of the law itself. So they interpreted it as access to the court. But I mean, nobody was denying you access to the court. But how is that going to help you? What does the right mean? And now, fast forward to the CCJ, and this is something this development is all credit and praise go to the Caribbean Court of Justice and none to the Privy Council, because they were holding back and strangling the law in this regard. So that if we look at the Jabari and the Jabari Neve case, this is what they said in the CCJ said. The right of protection of the law requires, therefore, not only law of sufficient quality, affording adequate safeguards against irrationality, unreasonableness, fundamental unfairness, or arbitrary exercise of power, it also requires the availability of effective remedies. It's a broad and expansive approach. It covers irrational behavior by the state, arbitrary behavior by the state that is manifestly unjust or unfair. And the remedies must also be meaningful. We forget that the judiciary is part of the state. So that even the remedies offered to you by the state through the judiciary must be meaningful. So in the Mahasaba radio license case, that was a discrimination case where the government had given a radio license to other persons, but they had refused to give one to the Mahasaba. We had won in the High Court. They granted a declaration that the right equality of treatment was breached. We won in the Court of Appeal, and we appealed to the Privy Council because the one thing the Trinidad courts did not do is give us the license. So you won, they gave you a declaration that your right equality of treatment was breached, and you get compensation. But how does that satisfy a rambunctious character like Sat Maharaj, who won T radio license? So he said, well, you know, we have to get it. He wants his license. Let's go to the Privy Council. The first question the board asks, we have never had a case where the appellant has won the matter in both courts below. Do we have a right to grant you an audience at all? Because you are not the loser, you are not the unsuccessful party, and how can you be appealing? So we had to cross that threshold to say, well, we are appealing because the shelter provided by the Constitution was not meaningful in this case. And it's an important thing to say that if you find that I'm a victim of discrimination, but you're not going to reverse the effect of the discrimination, then you are disabling the Constitution and the protection it gives to me. I have to have a meaningful remedy and relief. Lord Mance, in a very scathing judgment, which when you have time you must read, ordered them to grant the license and said yes, that the full panoply of constitutional redress and the remedies that you must get for the breach of your sacred fundamental rights, it must be such that it must be meaningful. Don't give me no bare declaration and say take money and compensation and go home. If we did that, George Daniel still couldn't go up the step with his wheelchair. You understand? So that, we just finished a case in the public service where when women marry and they change their name from their maiden name to their married name, you just have to provide the marriage certificate. But if you get divorced, you don't just present the divorce certificate, the divorce order, and get your name revert back to your maiden name. The state was asking you to jump through a set of hoops, including you have to do a deed poll and all kind of thing. So I challenged it on the ground that it was discriminatory towards women, because the same way I accepted the marriage certificate to change her name, well, then the divorce decree order should be equally accepted to revert back. But we've won that case, and there's a written judgment, and we've abolished that practice. Likewise, for example, in terms of protection of the law, we just finished the case of Dylan Ramraj and the Attorney General, where the police service of Trinidad and Tobago, if you have a tattoo, you can't join the police service. And that's been the case now for over 60 years. So I challenged it because what's the proportionality of it? They say, well, they want to make the police service look good, feel good, and appear to be uniform and looking real hot up. But I know, it's surely a healthy crime situation that they're looking so great and, good and so on, without tattoo, But the point is, what's the proportionality of it? What's the relationship? What's the correlation between having a tattoo and your ability to solve crime? More importantly, how on earth could it be right that in a modern-day police service, where you have departments such as cybercrime, you have departments such as the Financial Investigations Bureau and so on. I had a guy graduated with first-class honors with complete distinctions in his computer science degree. The police would go to him to help them to solve cybercrimes. They wanted to hire him. They wanted to hire him as well. But they couldn't. Because why? He had a tattoo. Right? So that's the state of affairs. So again, when people come to me, I question the question. The question, instead of going to write a letter about the tattoo and say, every other lawyer went to had written letters about the tattoo and say, well, it's a nice thing, it's a religious thing, it's a cross, this, that. I said, but why was that? Well, let me question the thing. Why do they have this in place? Instead of trying to justify the man having a tattoo, let's ask the question, why should he have to justify having a tattoo? I argue that the human body is an unpainted canvas gifted to you at birth by God. And that in the same way as an artist has the right to paint on a canvas in pursuance of his right to freedom of expression, that the human body was a canvas given to you by God that you too were entitled to paint on in pursuance of your artistic expression. And if it is not, provided it is not offensive or derogatory to anyone, there should be no reason why. So a man who's lost his, these are real cases now I'm about to tell you, a man who lost his daughter, his only child, and lost his daughter in tragic circumstances, who as part of his memory tattoos her name on his shoulder. That's a great guy to have as a police officer. So the guy whose father was murdered at home, and he was a child, and he wanted to fight crime and be a police officer and tattoo his father's name. Why not? Why not? In some religions and some great cultures of the world, having a tattoo is part of the culture. Part of the culture. And you get it sometimes in early stages of life. So why should you now have a permanent tattoo? You can't remove it, and lower down, you can't serve the state in any protective service. So the proportionality of it. And then that brings me to another case, which we recently won, but is going to be which is likely to be challenged in the Court of Appeal, is the minimum height requirement. There is a minimum height requirement to join the police service. And it's a colonial thing. I remember when I finished when I graduated from Pleasantville Senior Comprehensive, me and all the fellows who used to line together, we all went to line up to join police service and army and so on, because it was a great career opportunity, because it's pensionable, security of tenure, and you get in to serve the state, and you get in to put your little fitness and so on to some good use. And I remember being shocked when they told me I too short by 1 inch. I couldn't join. And then, my partner, couldn't as well. I thought, that's craziness. And I resolved, even then that bothered me. Finally, I got an opportunity to challenge it for a guy called Ronaldo. And we've won that case now. But again, the proportionality. Long gone are the law has to be a living, breathing instrument. So as lawyers, we must use the instrument of the law to achieve social transformation, social justice, and social change. That is what we must do. So therefore, in the police service, if the best guy for the job is a computer science geek and he's 1 inch short, what sense does it make to say that a man with 3 and 4 levels should get the job because he's 1 inch higher? And maybe that's why we can't solve crime. Because these kind of archaic, antiquated requirements that do not focus on merit and ability, that leads to the cultivation of a true meritocratic society. And a culture of meritocracy is what is holding us back. And there are many, many, many examples. Here, discrimination. Damien Belfonte, the Attorney General, a case I did in the Court of Appeal here. Every single Rastafarian that entered prisons, the first thing they did was to cut off the dreadlocks. That had been the case for decades. Why? They say national security. I said, well, what is it, national security? They say, well, them fellas them could hide things in the hair and thing and stab up man in jail and thing. I said, well, that can't be a reason. This is people's religion. They say Rastafarianism is not a religion. So I said, well, no, hold on. Well, I had a question before I answered that. I had a question now, well, what is the definition of religion in law? I don't answer the question. I question the question. So when you say Rastafarianism is not a religion, I grew up in Trinidad. You grew up knowing that three things, African, Indian, and Chinese. And let's matter now, white people. Hindu, Christian, Muslim, Baptist. We straight-jacketed. So I had to question, well, wait a minute, why isn't Rastafarianism considered a religion in the eyes of the law? Because the guy was a vegetarian from birth. Mr. Belfonte was a very, very devout man. His locks had never been cut before. So anyway, cut a long story short, I was able to persuade Chief Justice Sat Sharma in a very path-breaking judgment to recognize that Rastafarianism is a religion. The test is whether you have an honest and sincere belief in the values and the tenets of that, and it can be classified as a system of belief, which it is. And I was able to get them to declare that the cutting of the dreadlocks, which is a manifestation of their religious belief as Rastafarians, violated their rights. But again, proportionality. How could it be proportionate to say, well, firstly, did you have a legitimate aim? Absolutely. You want to keep the prison population safe. That's a legitimate aim. Did you have a good measure in place and a good explanation and so on? You say, yeah, the man could hide knife and sharpen a toothbrush on the ground and stab up people and put it in the dreadlocks. Sounds reasonable. Was there less intrusive measures? Absolutely. Let man loose all the locks and shake it if you want. Put a scanner next to it. But to cut it off? How does that balance and give due recognition and respect to his right to freedom of conscience and religious belief, which is protected by the Constitution, how does that give right to that? How does that give respect to that as compared to the respect of the rights of the community in the prison? So that's how proportionality, I've been using it in those cases. The recent one as well with the cremation case that Mr. Ramcharita mentioned, that's an important case. I mean, you had COVID, yes, and the whole world was, we all were in the throes of trying to fight the virus. But they had banned open-air pyre cremations. Hindus believe in open-air pyre cremations. And they had to undergo the indignity of having to, either bypass their rituals and do it in an indoor crematorium or bury. Because it was so expensive to do it in the indoor crematorium, some people couldn't afford it. And in some cases where families lost more than one family member, whilst you could have do it for the first person, you couldn't afford it for the second or third person. So now this is law in real life. It's good to read it in textbook and in classrooms, but this is real life. So this mother came to me, and she said, Mr. Ramlogan, I have a little problem, son. I said, what it is? She said, well, the old man dead. We was married for 60 years. She said, Beta, I have 7 children. And in the crematorium, they only allowing 5 people. She said, the Baba got to be one, the pundit. I want to go because I'm a husband. And that means I had 3 more places. She said, and every day them girl and them calling and tell me, Mama, don't forget I was daddy's favorite, and daddy go want me there. Don't forget I have to see my father. And you cannot deny me that right. And there's 3 places she have and 7 children. That is what she came to me about. And then I said, but wait a minute. But why do we have these restrictions in place? Because to me, if you go in an open air cremation, the way the breeze blowing is an open setting, you have greater opportunity for social distancing and everything else. But more than that, you could catch COVID from going in the bank, in the grocery, and we were already had resumed that. I could understand in the early stage when the science was very nascent and ambiguous about it. I could understand you earn the side of caution in the public interest. Right. So that you earn the side of caution in the public interest. But what about thereafter? The science had moved on. COVID was a respiratory thing. You get it from air droplets. The dead man can't breathe. I thought it was as simple as that. But anyway, we brought that case, and Justice Quinlan Williams, in a very in a brilliant judgment, has ruled that that policy was discriminatory towards the Hindu community, and not just Hindus, because there were many other people. In fact, researching it brought so much of historical context. Our first Prime Minister, Dr. Eric Williams, when he asked to be cremated, and no one realized that as a non-Hindu he would have asked for cremation, they had to put special measures in place to cremate the father of the nation, Dr. Williams, because we did not have an official cremation site in this country. In fact, there was a legal struggle to even have the right to cremate your dead recognized, and there's now a Cremation Act as a result of that struggle. But all these are historical, injustices and, all sorts of things. But the point is that proportionality again. Did you have a legitimate aim? Absolutely. You want to prevent the spread of COVID, and it's a fatal, it killing all people. So the aim was clearly legitimate. Was the measure proportionate? And was there a less intrusive measure? A less intrusive measure would have been yes. Let the people cremate in open air, but manage the numbers. Say only family only. 10 people, 20 people, mask up and social distance. Or alternatively, a less intrusive measure might have been to say, well, look, you can do it in the indoor setting, but make adjustments to accommodate the rituals and allow furthermore. The irony about it is that the judge actually found that the risk of transmission in the indoor crematorium was so much more significant than if he was doing it outside, based on the expert evidence, that they were actually putting people at risk. I cross-examined the chief medical officer for almost a day in court. But the point is, there was no justification for it. No justification. But again, the center stage really is on that. It has to do with the proportionality principle. The last big point I'll talk about. How am I reading for time? I see. Huh? Hour going? Oh, okay. All right. If I'm fed up, let me know. The next big thing would have been, the force, the preamble and the Constitution. Now, I've always, the Constitution is a remarkable document. Nobody should study law. Nobody should want to become a lawyer without reading, the first 10 pages of the Constitution, even the first 5. The Constitution begins with something called a preamble. It is a declaration of the values upon which our country has decided to forge a society based on the rule of law. It's very, very important. And immediately after the preamble comes the fundamental rights. It's section 1, which declares us as a sovereign democratic state. Section 2, that says that any law that is inconsistent with the Constitution is void. And then you go the fundamental rights in sections 4 and 5. The preamble provides inspirational force and muscle to the fundamental rights. And we have never recognized any inspirational legal force and muscle for the preamble. None. All credit goes to Justice Jamada in the Caribbean Court of Justice, who has been pioneering the law in this area. He has declared, perhaps I can just take you to that to show you what he said, because I think it's so revolutionary. I'll take it at slide 16. Oh, there it is. He first said it in the Belize International Services case. I mean, these are words that you'll expect from founding fathers of constitutions, and I mean, really great men. This is what it says. He says, this is so. This is because the state of Belize is constituted by its peoples. That's the first thing. We, too, in Trinidad and Tobago, we are constituted by the peoples that inhabit this island. It is their consent to be governed, and to be governed in a particular context and way, that brings into being what is agreed to, accepted, and recognized nationally and internationally, internally and externally, as the state of Belize. It is the consent that bestows integrity, legitimacy, and identity to what is understood to be Belize. Hence, the Constitution of Belize commences with the preamble, whereas the people of Belize. What he's saying here is, don't read the Constitution, Question the question. How did this Constitution come into existence, and why? The answer to that doesn't lie in the sections to the Constitution. It lies in the preamble. It lies in the spirit of the Constitution, not the text. The preamble is not a section in the Constitution, per se. So it doesn't have a substantive force. But now, this is a big change. Now, that preamble is now one of the biggest developments in the rule of law. He says, later on, he says, the preamble to the Constitution of Belize reveals some basic principles and values that have been averred to. The first clause affirms the nation of Belize shall be founded upon principles. Some of these fundamental principles are explicitly stated in the first clause, including human rights, freedom, dignity, and equality. As one progresses through the preamble, we discover many others. Social justice, participatory democracy, freedom based on moral and spiritual values, the rule of law, sovereignty, territorial integrity, non-discrimination, social security, etc., etc. Now, those things are so important. If you think about what's territorial integrity, look at what's happening with Guyana and Venezuela next door. Very important. When you think about what does the dignity of a human being mean? You think you'll find that and be able to understand that by the letter of the law? What is your dignity as a human being? If I ask you that, how will you answer it? And what right could we possibly formulate to protect your dignity? Not as a woman, not as a man, your dignity as a human being. It goes even deeper. It speaks to the right to freedom of conscience. It speaks to the soul. That is what it means. And that is the umbilical cord that ties the sacred fundamental rights to the preamble of the Constitution. So when Justice Jamada spoke, for example, about the concept of a participatory democracy, many years ago, when we had when President Robinson had removed Mr. Pandey as Prime Minister, he cited moral and spiritual values, for those of you who remember. And that comes not from the text of the Constitution, it comes from the preamble. Came from the preamble. But this concept of participatory democracy, what does it mean to have a participatory democracy? Well, it means two things. One is you must have a democracy, which means that it's a free society, but it also means that you have the right to participate in that democracy. That means you have the right to vote. You have the right to elect your leaders. Now, I use this preamble in the recent case of Ravi Balgobin Maraj versus the Cabinet of Trinidad and Tobago. The facts were very simple. The law is that local government representatives were voted into office and they had a fixed 3-year term. 3 years. So you elect a local government councillor, the law says they serve for 3 years. The government had amended the law to introduce a new term for councillors as part of a package of local government reform, and they had introduced a new term of office for 4 years. So that meant, well, they interpreted that as meaning that the life of the incumbents who were elected for a 3-year period, that they would now be able to serve the extra year because the law says that the term will be for 4 years. So, again, do you interpret that or do you question the question? I question the question by saying, well, can they really extend by extending the term of office, then suddenly give these people who were elected for a 3-year term an extra term without reference to the consent of the people in a participatory democracy? Where is the participation of the people? Is government by consent of the people. We give them the power to govern us. We do it. So where is the participation in the concept of participatory democracy? So I lost in both courts, in the High Court and Court of Appeal, but we won in the Privy Council because I argued that the concept of a participatory democracy means that you have a right to participate. And the people who you elect, they have to have your consent, your permission to govern you. And I argued that the right to vote is not to be viewed in a vacuum. The right to vote also implied that you have a right to elect your representatives. And if you have a positive right to do something, it also means that you must have a negative concomitant right. And the negative concomitant right is that if I have a right to elect somebody, I must have a right to vote for somebody. It means I must have a right to vote them out. I have a right to vote, yes, but having elected you, I must have a right to vote you out as well. You need my consent. I have a right to participate in the democratic process. So as a result of that judgment, the government had to have local government elections. And they've had that local government elections. But the point is, the preamble was what was important. That concept of participatory democracy. So if I take you to that slide to show you what the Privy Council said in that case, you will see, they didn't cite no big sort of case law, you know. I mean, it's often said there are 3 types of lawyers, you know. There are lawyers who, A, understand the law, B, know how to apply the law, and C, lawyers who understand the philosophy of the law. you must aim to be in the third category. It's easy to know the law. It's easy sometimes to interpret the law. Easy sometimes to apply the law, but not to understand the philosophy of the law. You could read the Constitution and you could understand what your fundamental rights are, but do you know the philosophy behind it? To know that, you have to go to the preamble. So this is what the Privy Council said in this matter. They said, the essential characteristic of a representative democracy, whether at a national or local level, is that the representatives are chosen by popular vote. In a modern democracy such as Trinidad and Tobago, all individuals have the right to participate in the popular vote, subject only to specified conditions and disqualifications. The right to vote, along the same code, the right to vote out representatives is as important as the right to vote in representatives. That was my line. So the right to vote in has a concomitant right to vote out. Doesn't matter who's in government. This is not about politics and government. It's about rights, about your rights. At the end of the period for which they were elected, the electorate had the right to decide whether they wished the incumbent representatives to remain in office, assuming they stand for re-election. Paragraph 33. A democratic society will necessarily engage other rights, freedom of expression and association, but the election of representatives for a fixed or maximum period is the foundation on which it is built. It is inimical to a representative democracy that the representatives are chosen by anyone other than the electorate. And this is what is important. It is not for Parliament, still less the government, to choose the representatives. That's a real loaded and pregnant statement. Parliament cannot choose your representatives. Only the people can choose their representatives. And in this case, they held, let's read on. If the amendments are construed to apply to incumbent councillors and aldermen, the effect will be that they have been chosen as representatives for an additional year, not by the people, but by the government, which brought the amendments into force. You see how the philosophy of the law comes into play? The man analyzes it as follows. He says, look, because you have a participatory democracy and you have a right to participate, a right to vote, if the government extends the term of office for elected people, then it's not the people choosing them. The extra period that they will serve, the people, they don't have the consent of the people. They don't have a democratic mandate to govern the people, because Parliament is the one that electing them for the extra period of time, not the people. Now that, I think, is significant reasoning about the philosophy of the law and the rights that flow from the preamble and the way it inspires constitutional jurisprudence. The last case I'll take you to is the last set of things is the Dumas case, Reginald Dumas. I want to pause and say a special word about Mr. Dumas. Mr. Dumas was a mentor and a great friend of mine. I knew him for many years, and he was a guiding light for many, many people in Trinidad and Tobago. He was a man of impeccable stature, wisdom, and integrity. And he was a man who I would often call, because although he wasn't a lawyer, he had a way of thinking that was beyond anything that I've ever seen. He had a visionary mind. He had a fertile and creative mind. And I would actually run cases by Mr. Dumas, and we would have very deep conversations about the philosophy of the law. You don't have to be a lawyer to have conversations about the philosophy of the law. But Mr. Dumas brought this case, Dumas and the Attorney General, and he was challenging the appointment of two persons on the Police Service Commission. But what's important about it is this. The state objected to Mr. Dumas having locus standi. Locus standi simply means standing to bring the case. And public law, it used to be that you have to be personally aggrieved or personally affected by the decision you want to judicially review. I couldn't judicially review a decision that affect you if it didn't affect me. It had to personally affect me. In other words, they refused to renew my liquor license from at a rum shop. That affect my livelihood. I could go and judicially review it. It must personally affect you. And then over the past couple of years, the biggest development in public law is the pendulum has swung away from private locus standi to public interest litigation. You no longer have to prove that it would affect you personally. So Mr. Dumas did not have to prove that 2 members on the Police Service Commission, who may not be qualified to be there, that somehow affect him, that somehow cause him personal loss. He didn't have to prove that. Why? Because the pendulum has swung away from private rights, and the focus is on on vindicating the rule of law. So the court's role is now not to look at such arid technicalities as standing, because somebody who has little or no standing may have a great case that impacts on the rule of law. So, for example, in the Rafi Balgobin case, what if Mr. Balgobin says, well, I don't vote? Should they shut him out because he has no standing to bring a case about elections? The answer is no. If the case is one that affects the rule of law, the court has to focus on that now. So, Mr. Dumas, this is what they said, upholding the judgment of Justice Jamada, speaking for the full court in the Court of Appeal. This is what Justice Jamada said. And forgive me for coming back to another one of his judgments. It's just that it was upheld by the Privy Council. Here we are. In this socio-political constitutional context, there is very good reason to adopt more relaxed standing rules for constitutional and public interest litigation, especially where it concerns and raises constitutionally related issues of unlawfulness and the observance of the rule of law. Public interest litigation in non-Bill of Rights constitutional review permits citizens to contribute to both participatory democracy and the vindication of the rule of law. So you are participating in the democracy of your country by bringing a case to say the state is doing something wrong. That's how he rationalizes it. By facilitating it, one aspect of the needs and aspirations of the local society is fulfilled. The approach to be taken on the issue of standing, therefore, is flexible and generous, bearing in mind all the circumstances of the case, and of course the need to exclude busybody litigants who have no genuine interest in the issues raised and have demonstrated no credible engagement in them. The public importance of the issues raised and of vindicating the rule of law are significant considerations. That is the biggest development, the last one, that you no longer have to prove that you are personally aggrieved and affected by it. You no longer need to prove that. That is why, for example, in many of the cases that I've done, they are based on, some public interest litigant who wishes to challenge something. We've challenged the appointment of the Commissioner of Police. We challenged it when Gary Griffith was there on the basis that they didn't comply with the constitutional machinery that was prescribed in the Constitution. We won that. We've challenged Ms. Christopher's appointment as well. And that is still before the courts, so I wouldn't say too much about that, right? But the law can be used, and the Constitution can be used in almost any circumstance that you can think about. The question is, are you going to be responsive to the question, or are you going to question the question? That is the question, ladies and gentlemen. I urge you to not be so quick to respond to the question, but to pause for cause, take a moment of detached reflection, and ponder on the question itself to see whether the hidden assumptions upon which the question itself is constructed are fundamentally flawed. And that is my message to you today. So I leave you with those words, and I'm open to questions from anyone, if there are any questions. Well, whilst you're thinking about your questions, I'll give you, as I said, the law is so dynamic, and as you can tell, I enjoy the law very much. And the last case I did was a case on adult sex toys, because in this country there's a very old regulation where customs can seize indecent and obscene articles. And of course, someone came to me, and the case was, they lost, the customs seized the sex toys that they were importing. And of course, we are a very finicky society, but the point is, the person was very open about it. And when I went into it, I was amazed at how this thing is so important. The disabled community, first and foremost, they use sex toys as part of their therapy if they're in a wheelchair. The Rape Crisis Center, victims of rape and incest. Sex toys are an integral part of the rehabilitation and counseling and sexual therapy to gently reintroduce them to the concept of sex. Gay couples, a necessity. Women whose husbands work on offshore platforms and who wish to remain faithful in support of the institution of marriage. And a spiraling myriad of other things that I did not think about. But I was amazed at how much people came forward to give evidence from their different perspectives. Single women who haven't found the right partner and don't wish to, and believe, and they're fundamentally Christian and wish to remain a virgin until their wedding. So the sex toy actually upheld the tenets of religion, they argued. All of these people came forward, and all of that evidence I placed before the court to show how multidimensional and multifaceted it is. So in the maternity case that I spoke about earlier, women who pursue careers. Only I want to go and take a little teaching work and be a little bank teller. All I want to be a lawyer. But the point is, it makes it harder to find a life partner. Because it's out of my bright fellas out there. And all of them want to, and they're still growing up with the images of their wife as their mother teach them. Joking clothes and for childbearing and child rearing. So the boy of today is not being prepared for the girl of tomorrow. So we have that problem in the legal profession. But the point is, it also means when you do find the right partner, you start a family later on in life. And because you start a family later on in life, biological imperatives are such that you need to have children quickly, so that the person I'm representing is one such career woman. She had to have two children within the space of 24 months, because biologically she might not have been able to have afterwards for certain reasons. But this is the real life aspect of the law. I'm trying to connect what you read in the exam room and what you're teaching abstract to real life. So the sex toy, yes, they go read the judgment. Read it, Justice Ravi Balgobin again, and the Attorney General, Shanice Katik, and the Attorney General. But these are real life cases. And you can't afford to be finicky about things, you know. People come to you with amazing cases, and you learn so much about life. You learn a lot about them. So anyway, and for those of you who want to know whether I asked for a demonstration or I viewed the evidence, maybe. Yes, thank you. Yes, it's Ruth. I think it's Ruth Barrett. I'll get I can look. For those of you who might be interested in this because it's too fast to follow, I'm happy to email it to Mr. Ramcharita or to you directly. My email address is my first name and last name, anandramlogan@outlook.com. Feel free to email, and we'll just send it to you so you can have it. Yeah. But so I can get that judgment and send it just as well. So that's fine. But yeah, there are a lot of. There's a lot of discrimination that's built into our society and built into our system. I mean, the case of Yoklan Balwant and Josine Johnson in the Privy Council, in the public service regulations, you can dismiss a woman for spending too much time with her family after she's married. But there's no corresponding provision for men. So in that case, in the Privy Council, I challenged it for Ms. Josine Johnson, who is a great friend, and she was upset about it. She had found a life partner, but she said, but the man who was above her, she rejected his romantic overtures, and she was worried that if she go and marry this fellow now, he will pressure she and fire she on that ground. So she came to ask my advice about how to treat with him. And then I said, well, again, before I respond to that, let me question the question. What you say about the law? You could get dismissed. I said, well, what about the man? She said, no, I do not like a man. I said, but then what are you doing there? So, again, real life situation. Yes, sir. If you could say a name as well, I'd appreciate it. So I'll just get to know you all. Good afternoon. Quincy Jones? Okay. That's very, very, very interesting. Well, the first thing is that obviously the Privy Council have no Guyanese in it either, and they would have presided until they abolished the Privy Council. It's an interesting point, but it goes to the philosophy of the law. In the same way, as I said, in the concept of a participatory democracy, you need the consent of the people to establish the state and the government. I also think that you need to have people who understand the social conditions and the culture of a people to govern over them. That will obviously bring into the central focus the debate about the CCJ versus the Privy Council. And I am ambivalent about it because I'm not yet sufficiently convinced. What I do say, however, is in answering that question, I will ask the question, how did the Caribbean Court of Justice, before I respond to the question, I will ask myself, how did the Caribbean Court of Justice come to govern the people of Guyana without a referendum? How is it that the Caribbean Court of Justice or any court can, when we elect a government and the government establishes the judicial commission that appoints judges and so on, there's a democratic nexus. The architecture of the state is infused and inspired by the democratic credentials that I bestow upon it when I put X. I authorize everything. When I vote, I authorize every single thing that is in the panoply and structure of the state. It comes there because I gave my consent for it. So the question becomes, philosophically, in a concept of a participatory democracy, where is it that they get the right of, and the consent of the people to do it? That is why in some constitutions you have a clear provision for a referendum. In St. Lucia, that very issue raised in St. Lucia has reared its head, because there is in fact a referendum provision, and there was no referendum held to switch from the Privy Council to the Caribbean Court of Justice. So it's a fundamental issue, but what I will say is I think the consent of the people is an absolute prerequisite if there is to be the respect for the rule of law administered by anyone. So thank you. Hi. Mr. Barrow? Okay. No.
Thank you. The applicability of rights contained in like international treaties and their application to domestic law. So is it possible to implicitly constitutionalize these rights in international treaties? And can they give rise to a breach of constitutional rights domestically? For example, like the right to protection of the law?
Yeah, that's a brilliant question. The answer is yes, and that's another, time did not permit me, but that actually was my next slide that I had in mind. I took it off before I left home because I thought it would be too much in terms of time. But insofar as you have to determine whether a law is rational and proportionate, one of the things you'd have to have consideration to is, well, what is acceptable internationally? And what is the international norm in other functioning mature democratic societies with respect for the rule of law? And in the very election case, for example, I had gone through all of the international law and the right to vote and all those things. But I've just completed what is probably the largest ever prison conditions case in this country. And in that matter, it was all about international law. All the treaties to which we are a signatory that prohibit cruel and unusual punishment, and the question of whether having 10 grown men in a cell that is the size of 10 by 10 or less, sleeping on the floor, sleeping on urine and feces-ridden carpets without even a toilet. They still use slop pails. And for 10 years you could be innocent and have to be in that condition. All of that, the law was based on international law as to what the minimum level of severity in terms of conditions will be, such that it crosses the fine line where it then affects and compromises the dignity of a human being. Where does the treatment by the state, when does the treatment by the state cross the line such that it violates the dignity of a human being? That means that they no longer treat you as a human. So my argument is that the prison conditions are so subhuman that you have lost your dignity as a human being in the eyes of the state because the conditions are not fit for humans. That's the argument. So, and that comes by reference to how other countries and societies treat our fellow humans. So what is cruel and unusual in Trinidad and Tobago cannot be not cruel and unusual elsewhere. That's the idea. There will be variations, of course, but international law is important. In the case of Brian and Sasha Sipasad and the Attorney General in the Privy Council, they held that your international treaties, whether incorporated into domestic law or not, but international treaties to which you're a signatory, they give substantive rights, and they can reinforce other rights that you have. It wouldn't give a substantive right of its own, but it can reinforce and buttress and give legal context and flavor to your local rights, and the interpretation lens would be through the international treaty and the Constitution. So the answer is yes, after that long speech. Anybody else? Oh, yes.
Good afternoon, Senior. I liked how you started, well, you kind of lead it into my question when you mentioned cruel and unusual punishment, because my question goes towards the savings law and considerations of the death penalty, of course. Especially under the microscope of the current crime situation, the split views that we have with the CCJ and also the Privy Council, Chandler, Neves. What are your views in terms of whether there should be a total abolition of the savings law clause, or should there be a bringing into conformity of certain laws that some that are outdated but are necessary in today's world, but bringing into conformity those that have no place here at all?
Well, I mean, I am a firm supporter of the Caribbean Court of Justice jurisprudence on the savings law clause. I think having forged our society based on laws that were our colonial masters would have bestowed upon us, where they didn't have the they didn't have to have the respect for the dignity of us as human beings. We still, I mean, it was a Christian society. So that when, for example, you look at the law of blasphemy, the law of blasphemy in this country is that you can only commit a criminal offense of blasphemy in relation to a church. Not a temple, not a mosque. You can, and it's so specific, it is relative, I forget the wording of it, but it's very unique. The Shouter Baptists, there's so much that's still criminalized, even now, but it's saved law. And you can't challenge it. But a lot of the laws that don't cover other religions, for example, because we would have inherited it from Britain, we can't challenge them. The case of Balwant and Johnson, I mentioned Josie Johnson. The Privy Council found that regulation was unfair and discriminatory towards women, to say that you could dismiss them because they're spending too much time with family, but there's no corresponding such ground of dismissal for a man. They found it was discriminatory, but they said it was saved law, so I lost. They called upon the government to change it. Nobody has. So the short point is the savings law clause absolutely needs to be removed. And we can't preach. You know, we have a very legal, we have a legally hypocritical way of viewing things. And that is that we want to talk about forging our own national identity, forging our own Caribbean identity, forging our own Caribbean jurisprudence. But we can't call upon governments to remove the savings law clause. And we still, you know, keeping all them old antiquated laws that our colonial masters gave us. We don't want to be, we're scared to be modern. And hence as well, the ambivalence about, you know, the CCJ, the Privy Council, and all of that, you know. But, you know, I think it's a great question. It's a burning academic debate. The Privy Council has settled it in Chandler and the Attorney General, so we are now stuck with it. But the long and short about it is that we, unless Parliament, they've said it's a job for Parliament, not for the court. But I think it should be removed. Thanks. You're from Guyana? Tobago, okay. My bad. All right, don't sue me. Anyone else?
So while I am sure Senior is well accustomed to standing for hours on his feet before the law lords, he has been standing for some time. So I would like to firstly invite him to have a seat if he wishes, but about 5 more minutes for questions. So please feel free to think about the questions and direct it his way. He has indicated that he is willing to stay a bit longer. I know we had a 12:45 end, but let's try to do it in 5 more minutes. Thanks.
Right, but I think it seems as though I've exhausted you and imposed myself enough on you. So I would just want to say thanks very much to Ms. Samru and Mr. Ramcharita and the staff at Hewarding Law School for giving me the opportunity to address you all and to share some of my experiences and legal adventures with you. For those of you who are thinking about a career in public law, it is for me the most exciting field in law. It is what I'm most passionate about because it allows you to use the instrument of the law to achieve social justice and social transformation. It really is a David and Goliath battle, and you know, the law becomes your slingshot and your voice becomes the pebble. And that, I really do think that as young lawyers, no one can practice law, should be allowed to practice law without a basic understanding of public law, constitutional law, and judicial review. I'm always willing and open to share ideas to assist students. For those of you who are interested in a career in public law, as I told you, my email address is anandramlogan@outlook.com. I have, I do work throughout the Caribbean, but have links with all of the other people who are similarly of like mind. And if you want to pursue a career in that field, by all means, feel free to send me an email, your resume. It doesn't matter. And once you have the passion and the commitment for the rule of law, it'll be fine. Thank you all very much.
Thank you once again, Mr. Ramlogan. I'd now like to call upon our director of the Legal Aid Clinic, Mr. Ashok Balrup, to give the vote of thanks.
Good afternoon, everyone. I'm going to be quick because I know we've moved into the lunch period, and I'm really happy that people have stayed. Okay, so good afternoon, everyone. On behalf of the Hewarding Law School, I extend my heartfelt gratitude to everyone for being here today. First and foremost, I would like to express our deepest appreciation to our esteemed speaker, Mr. Anand Ramlogan, Senior Counsel. Your insightful presentation has not only enriched our understanding, but also inspired us to delve deeper into the complexities of public law and question the question. Your passion and expertise in the subject matter has truly illuminated our path for us to navigate through this impactful area of law. Thank you, sir. Further, I would like to thank Mr. Roshan Ramcharita and the members of the Public Law Specialist Clinic who have worked tirelessly behind the scenes to ensure the smooth execution of this event. Your dedication and hard work have played a pivotal role in making this lecture a resounding success. Last but not least, I extend my gratitude to all the attendees for taking the time out of your busy schedule to be here. I know everyone has exams, so it's very commendable that all of you made the time to be here today. Your presence at this gathering makes it all the more meaningful. And we hope that the knowledge gained from this lecture will continue to resonate with you in your personal and professional endeavors. In closing, let us carry forward the insights gained from today's lecture and apply them in promoting justice, fairness, and the rule of law in our society. Once again, thank you all for your participation and your contribution to this enlightening discussion on public law. Thank you, everybody.